So, hi everyone, it's Grant Abbott speaking, and welcome to this session on the ins and outs of testamentary trusts. With myself, I've got Michael Jeffries from LightYear Docs and Jam Investments, and also Tony Anamourlis, hopefully coming on a little bit later at Abbott Mourly Lawyers. What we're going to look at today is what is a testamentary trust. Many of you probably have been either got some yourself or you've put clients into testamentary trusts before, not really understanding what they are. I think we all understand what a discretionary trust is. We settle it with an amount, maybe $10 or $100. Then we effectively go down the process, buy business, buy properties, borrow, and we just carry it out ordinarily our trust responsibilities. There's quite often a appointer of the trust. Obviously is the person who can hire and fire or appoint and remove the trustees, depending on the constituent rules within inside the trustee. Obviously, we need to have a trustee, which is absolutely crucial. Quite often that can be a company, such as a special purpose, leading member discretionary trustee company that we've got on the LightYear Docs platform. Alternatively, we can have individual trustees. And of course, then we have primary beneficiaries, or a whole range of beneficiaries, which can also include bucket companies, etc. So we're pretty okay with discretionary trusts. And then from that, we've also got an ability to create a whole lot of other trusts. Some of you may, well be aware of a special disability trust. We do those through Abbott Mourly. The benefit there is the money that is settled into that trust is excluded from assets test purposes under Social Security. So it's a very important trust. It can also be useful when we have a look at that as well. It can, if it's settled with monies from the estate, is also very beneficial as well. So testamentary trusts, we'll go into those, but we're all pretty comfortable with the idea of trusts, except I'm finding with a lot of you is that when we start talking about wills and estates, we tend to freak out from that perspective. Notwithstanding the fact that you can go down the local post office and get your own do-it-yourself will, where you put in your details and you're off and running. So I want to take you through today. I'm going to take you through why testamentary trusts, the impact of testamentary trusts. We're going to also have a look at the legislation around accepted trust income, which essentially means that under the trust provisions of the Income Tax Assessment Act 1936, minors are obviously taxed, subject to penalty tax. I think it's $480 or thereabouts, which is tax-free, and then it goes up to 60% and then back to top rate. So what we want to do there is we want to essentially look at that accepted trust income, and there's a number of trusts involved in that, and that's encompassed in section 102 AG of the 1936 Act. So I want to go through that. I've then got a case study with a disabled child, with a potentially disgruntled child or child who may end up, who's estranged from their father, life tenancies. I'm going to take you through, I want to take you through the documentation first around that to show what it looks like. Cover each aspect of that, and then what we'll do is we'll actually reverse. We'll go back and build that exact same documentation in the LightYear Docs platform. So we're going to get a really good understanding of the law. We're then going to go and have a look at a case study. So we know the law, we find our cases, then we start to apply the law. And I'll show you the document, the end document that comes up out of the testamentary trust. And then in what we'll do is we'll then go and use the LightYear Docs system. So you're not, the system itself isn't that sophisticated. Sorry, it's very, very sophisticated, but all the hard work is being done for you. So the actual utilization of the system by anyone who knows how to go online and do a trust deed or an SMSF online, when I take you through, you'll see that AM lawyers or Abbott Mourly lawyers have done all the grunt work for you within the system. And then it's a matter of ticking the relevant boxes. But look, we'll go through all of that. So it's a good session. We also want to talk about it. There's three different ways When we get into simple wills and EPOAs and advanced healthcare directives, I'm not sure if you saw, but the Western Australian one is up today, and Victoria and New South Wales will be coming tomorrow, along with our discretionary trust upgrade for non-foreign purchaser trusts. So that'll be up today as well. But notwithstanding that, we want to make sure that we have a really good look at it. For simple wills, the system works for itself. For those who are on the strategists, LY strategists or licenses, you can just pump those out. Embedded in there is obviously Abbott Mourly have done all the work for you for that. So it's a pretty simple scenario. But where you've got disgruntled children, not everyone's going to get the same sort of benefits. If you look as though someone's going to make a family provision claim, got disabled children, life interests, those sort of things, then we start to move away from simple wills and start to build in testamentary trusts. And, there's a number of reasons for those. Testamentary trusts are prima facie discretionary trusts, but they can have limits on there. For example, if it goes to a minor, we can put in there that, they become trustee appointor, at age 25, 30, 35. They're not allowed to take any capital out until age 35. So we can start to put some fixed elements around it, which makes it a hybrid trust. So it's both discretionary and also a fixed element there, which fits perfectly. So in those ones, though, that when you're going through the process again, you'll see, I want to get you the confidence, again, the law, case study, application of the law, preparation of the documentation. I want to get you to a situation where you're comfortable about doing this on our system, and try it again. I think the most important one there is, from Travis, who's on who's one of our sales guys. He goes through and says the most important thing is to do it for yourself, and then you'll find out how it's not difficult, how simple it is. But we've got a solution there for you. And also, I know a lot of our accountants are really just too busy at the moment. They know they want to get into this space. Clients are asking for wills and stuff like that, but they haven't got the capacity. I want to show you a solution there that Abbott Mourly, we can take that off your hands, effectively work closely with you and the clients, but we do all the preparation and dealing with the clients. And then obviously we'll have a look over their trust, their super, all of that, and deal with them. But then there's an administration fee paid back for you in that regard, because we're working in tandem. Anyway, that's a lot to come through. That's sort of a bit of an agenda today. So let's start to go around. So I'm going to switch here, and what I'll do is I'll just take my video off, and then what we'll do is we'll start to look at my screen, and I'll work through there. So testamentary trusts are trusts that are basically created on the death of a person by another person for the benefit of one or more of the deceased intended beneficiaries, which can include a spouse, child, or broader bloodline, such as family. It can include charities, companies. It can include basically anyone that you want. There's no limit generally in terms of trust as to who can be paid for. Surprising thing, though, is testamentary just simply means that someone has effectively passed away. So that you'll see when we get into the law, they can actually be created by any person for that matter. In the old days, they used to be created by an employer. And so we're looking around about 100 years or so ago. So they'd be created by an employer well and truly before superannuation, for the benefit of the spouse and also their children. Usually if it was a spouse, it'd just be paid to them. But if there was only children left, then quite often it would be settled into a trust, a testamentary trust, by the employer. We also know, I'll have a look through the legislation, but the testamentary trusts that we're all comfortable with, or the legal profession has bread and butter for, is usually created by the executor of the estate of the deceased. You'll see when I go into the law a little bit, there's been some sweeping changes there, anti-mixing legislation or anti-avoidance legislation for just testamentary trust from a will. But you also find when we get into the law that a trustee of an SMSF can also create a testamentary trust. Believe it or not, a trustee of a discretionary trust can create a testamentary trust, as can a company. So it's going to depend on where it comes from, whether you get the exemptions under Section 102AG of the 1936 Act. But really where we need to do is find out where the settlement sum comes from. So, for example, an employer may put in $200,000 into a trust for the benefit of the children of an employee. So we know where the settlement sum comes from. We know the amount of the settlement sum. So the question is, if it's for the children, do they, in fact, get the ability to be taxed at ordinary marginal tax rates? In fact, if I asked you, what do you think? Do you think it's going to be there? What about a trustee with discretionary trust? If they take an asset out of that discretionary trust and settle it for the death, on the death of another person, would that be considered one of the beneficiaries? So we need to have a look at really the key feature for us from a tax perspective. And of course, the trust we love for asset protection is, where does that settlement sum come from? Is it the employer, the discretionary trust, the SMSF, or is it the executor estate, the will? So we'll have a look at each and every one of those. Now, again, the purpose of a trust generally is for asset protection, so that we might settle it in there for the benefit of a child, excluding the spouse or their spouse who's not bloodline, and then essentially for the children, the bloodline children of the beneficiary who it's been settled for. Now, that also protects for bankruptcy, divorce, looking after the beneficiaries where they're incapacitated, handicapped, or not able to manage their own money. So there's a wide range of reasons why we would use a testamentary trust. Now, of course, once we set up a trust, there's some rules around it, which is important. Now, we've got the special tax concessions, but not all testamentary trusts are going to be the same from a taxation perspective or an asset protection perspective. So importantly, from this perspective, and you've seen the old Miller versus Taylor case we've talked about before, the issue is, if I create a SMSF Death Benefits Trust, so the trustee of an SMSF creates a testamentary trust, and let's assume now that it's covered as accepted trust income, then in those circumstances, what transpires from there is that sits outside the family provisions claim. A family provisions claim is a state-based claim whereupon an eligible person, who may include the spouse, a de facto, children, potentially grandchildren as well, all of those ones effectively can make a claim against the state if they've been left out or they feel as though they haven't received as much as they should have out of the estate. So if I do an SMSF Death Benefits Trust that is created by the trustee of the SMSF, then that is excluded from the family provisions claim. The same way, if I've got a life insurance policy, and again, the proceeds go down to my children, and I create a trust out of that, insurance proceeds trust, that doesn't go into the estate because it's payable from the insurance company. Likewise, that doesn't go into the Family Provisions Act, or it's not impacted by the Family Provisions Act. Likewise, if an employer creates a trust, a testamentary trust on behalf of my children, again, that sits outside of the estate. So the typical thing is that when I do a testamentary trust for my estate, I've got to be, I can use it for bankruptcy, divorce, looking after incapacitated, handicapped, or children who can't manage their own money, or children when I'm incapacitated, they've got drug issues or alcohol issues, etc. So from that perspective, we've just got to be careful that when it does go over to the estate, it may well be subject to a family provisions claim, which means it's at least 2 to 5 years before that will be settled. So let's have a look at the taxation side of things. And I was going to go through and you've been on enough webinars and enough training where generally the person will say, well, this is how it is. But no, again, for you to get your confidence up, and this has always been my rationale. Some of you know I did a Master's of Law, but also was a teacher there coming through Monash Teachers College. Didn't finish it, got very close, just couldn't handle teaching kids, so sorry about that. But anyway, I ended up teaching. I'm teaching you guys now. So in 2000, I started Australia's first specialist SMSF advisor course on the premise that, look, I could teach the law. I know the law and I could teach the law to any accountant, financial planner or mortgage broker or anyone, really. And by understanding the law and you reading the law, and I know a number of my students still go to the law, is that effectively by understanding that law, it gives you a huge degree of confidence because you've read the law, you understand what it is basically saying, and then you can say, okay, well, I understand how then to understand the law, then apply it to a set of facts, which is the most important scenario, as opposed to, and you know very well, you can be on a number of, if you've been in some seminars or on some conferences, you'll have one person saying this and another person saying completely something different. But really, at the end of the day, the answer is always in the law. So let's just go through, and we're talking about accepted trust income for minors. So subsection 2 of that section basically says, subject to this section, an amount including the assessable income of a trust estate is accepted trust income in relation to a beneficiary of the trust estate. So accepted trust income is obviously that is excluded from the penalty taxes for minors. So whenever we see that accepted trust income, it means that it's excluded from the penalty taxes for minors, which is one of the big reasons why we set up these testamentary trusts. As an aside, and put it just if you park it there, you'll actually, I'll come back to it in a second. To the estate, to the extent to which the amount is assessable income of a kind covered by subsection 2AA, which we need. This is a brand new rule within the testamentary trust provisions, and really anyone who's got testamentary trust in their estate really needs to go back and have a relook at their testamentary trust, because there's now an anti-mixing rule in there which wasn't considered before, and certainly I know there's a number of existing testamentary trusts are going to get caught. Surprisingly, this doesn't apply to SMSF Death Benefits Trust. So let's go and have a look. So is assessable income covered by 2AA of a trust estate that resulted from a will, codicil, or order of a court that varied or modified the provisions of the will or codicil, or an intestacy, or an order of a court that varied or modified the application in relation to the estate of a deceased person of the provisions of the law relating to the distribution of the estates of persons who die. But essentially, as you can see, so this is a trust. Let me just get my little annotator here so that we can see, because I like pretty little annotators. So you can see here that it's a trust estate. There's assessable income going to a beneficiary, and it flows from a will, but it's subject to 2AA. Does that make sense? So let me go through. Out of the will, I'll do it a different way. Out of the will, there springs a trust estate to which there is a beneficiary, which may include a child beneficiary. And if it falls within the line of section 2AA, the assessable income, then it's accepted trust income and is taxed at marginal rates. So I brought in 2AA for you. It's probably, I would say that 99% of certainly suburban lawyers wouldn't even know what this is. And certainly it's brand new. It's only probably around about 3 months old. So let's go through it, because remember, the prior section is it has to be assessed in order to get the accepted trust income. The assessable income has to equal what's required under 2AA. Does that make sense? So let's go down. So for the purpose of 2A, assessable income of trust estate is a kind covered by this section. That is, its assessable income is derived by the trustee of the trust estate from property. So there's been property that's been settled by the executor into the testamentary trust. Does that make sense? So that's pretty basic there. Now, the property satisfies any of the following requirements. The property was transferred to the trustee of the trust estate to benefit the beneficiary from the estate of the deceased person concerned as a result of the will, codicil, intestacy, or order of a court mentioned in paragraph 2A. So that's just a resetting of 2A, probably a better example. In fact, it's probably a better description than what I was saying. The second one is the property represents accumulations of income or capital from property that satisfies a requirement in subparagraph 1A. So the property that we have in there may well grow. So there's an increase in the underlying capital, and likewise income may be capitalised. So that all parcels up, so that when we have a look at the assessable income has to be derived from that property, or income or accumulations from that property. And again, the property represents accumulations of income or capital from property that satisfies a requirement in subparagraph 2. So, for example, in the past, prior to this legislation, you would have maybe $200,000, which would be settled into a testamentary trust from the will by the executor of the estate, and we'll go through and see what that looks like a little bit later on. But then what would happen is that the parent, who's obviously not dead, would then settle, or the individual would settle another $100,000 or $200,000 into that testamentary trust, so that the assessable income from there now was effectively the will, or the property from that will effectively became polluted. And so what happened, though, is when the assessable income came out under the prior law, which was 2A, and it obviously didn't include 2AA because it was relevant to the trust income and the trust estate, effectively any income coming out of there was subject to, obviously the minors were able to take any income as marginal tax rate. So it's a great way of washing money into the testamentary trust to the benefit of children for their ordinary rates, but no longer. So now we have to partition, so that, and this is where things get a bit painful, and certainly from an accounting perspective, we'd end up 2 subtrusts within that testamentary trust if we wanted to go down that track. But generally, we're not going to do that anymore, so we're only going to settle it with property from the trust estate. Otherwise, I'm going to have to partition. I'm going to have a trust for property from the estate and trust from elsewhere as well. Okay, sorry. Okay, so let's go on. Is there any questions around that one? So that's a brand new provision. If you already know people with testamentary trusts who are washing stuff through, you've got to be really careful, because what happens there is if it's mixed, all of the income coming out of that testamentary trust is taxed at penalty rates for minors. So you lose that accepted trust income. So that's our basic one. That's our good, strong core testamentary trust, which I'm going to take and show you a little bit later when we apply the law to a case study. So when I apply the law to a case study, I'm looking at 2A and 2AA. But again, while we're here in the legislative mode, we've got our brain there, I want to show you some other trusts that are available there. So John Gowing have got there, I'm unclear on whether refunds of franking credits paid to minor beneficiaries can be deposited back into the testamentary trust without contaminating. Unfortunately, John, if you get a franking credit refund, which obviously would go to the beneficiary, and we put that back into the testamentary trust, which was a good strategy before, and was a typical strategy before to build everything up. Previously, so prior to 2AA, that was all okay. Someone to pass down that extra income or capital that we've put into the trust, that property we've put in, which is the refund of franking credits, all would have come out and been assessable marginal rates, but now no longer. Since the introduction of 2AA, which I think applies from the date of the Royal Assent, then essentially that would then be contaminated from there, John. Again, so this is quite a fundamental change to, this is quite a fundamental change to the way testamentary trusts operate. And just note, which is quite interesting, just note this provision here only applies to what I call testamentary trusts that flow from the estate. So Section 102AG also applies to the following trusts. Is derived by the trustee of the trust estate from the investment of any property that devolved for the benefit of the beneficiary from the estate of the deceased that was transferred to the trustee for the benefit of the beneficiary by another person out of property that devolved upon that other person from the estate of a deceased person was so transferred within 3 years after the date of the deceased person. So this is not a 2A, so this is a 2D. So it is quite bizarre. And again, sometimes I don't think about it. I don't have to do a bit of research. But if, for example, we have a property that's sitting there and the property is then paid to the minor, then the minor can then go, obviously the minor child, a testamentary trust can then be established up to 3 years after that date. Interestingly, from that perspective, the 2AA doesn't apply. So it would appear that if we settle the property on the minor, then they create the testamentary trust from that point in time. If that gets that mixing route that John Gowling was talking about, refundable franking credits, it appears as though 2AA doesn't apply, because 2AA only applies to 2A. This is section 2D, if that makes sense. So it looks as though, again, it's just a little bit of a different way of looking at things, but it just shows you how to get around 2AA quite easily. Of course, the problem is if we settle it into the child or anyone, an adult child at that point in time, if it goes into their own hands, you've then got to coerce them, not coerce, or ask them to put it into a testamentary trust. But if they're bankrupt, it goes. So the asset protection side generally is lost in that instance. So it does happen, but it's nice to know that legally there's our setting it up from the will under 2, subject to 2AA, again, that non-mixing or that non-pollution. And 2D is that even if it's gone into a beneficiary, that you've still got 3 years from the date of the deceased to set up a testamentary trust. So that's our classic will testamentary trust from the estate. And again, remember, these are subject to family provisions claims. Now, a couple of other ones, subsection C. So obviously 102AA doesn't apply to 2C. It only applies to 2A. So when I go down here, C, so it's derived by the trustee of the trust estate from the investment of any property transferred to the trustee for the benefit of the beneficiary. So again, same sort of deal. But remember, if we go back to A, it says it's actually derived from a will, codicil order of the court. Here, we don't have that issue because it basically says it's directly as a result of the death of a person and under the terms of a policy of life insurance. So again, what we can have there is the proceeds of a policy might be to my children, if you've got my children, my grandchildren, whoever, then if I set up a testamentary trust, which sits, the benefit here, a huge tick, it sits outside of the estate and hence a family provisions claim. And as a consequence of that, ostensibly what would happen is then the children who are beneficiaries of that estate effectively would receive any income under that insurance policy. And remember, it's going to be the proceeds, any income from those capital proceeds effectively would be treated as ordinary, would be taxed as income under ordinary marginal tax rates. So that's a life insurance proceeds trust. We don't put that into the estate because if I put those proceeds into the estate, then I'm going to get caught by 2AA and family provisions. So you can see why there's a fundamental changing in testamentary trusts. Probably hasn't been picked up by lawyers yet, but again, you guys right at the front of things. This is my little favourite. So it's transferred to the trustee the benefit of the beneficiary directly as a result of the death of a person and out of a provident benefit or superannuation fund. So again, to be paid out directly, it can be paid out as the trustee. So that what I would do there and what we do in our SMSF wills is the trustee of the SMSF can effectively create an SMSF death benefits trust. So we don't put in their SMSF testamentary trust because it's too confusing for people. But suffice to say, an SMSF death benefits trust as a insurance proceeds trust under 4 and 5, both of them have any income is accepted trust income for minors. So it's taxed at ordinary marginal rates. Here's the other one, directly as a result of the death of a person by an employer. So we can have an employer trust, the same thing. So again, you can see there's quite a range of these testamentary trusts that you're really not aware of. This one here is a result of a family breakdown. I won't go into this, but at some point in time we will. We'll be doing a couple of child maintenance trusts at Abbott Mourly, and essentially what it is we can settle property into a child maintenance trust, and effectively then income and capital distributions for that property is taxed at the marginal tax rates of the children. So it's a great strategy again from that perspective to save a bit of money, and certainly I did that through my child support. So if anyone needs to do that, that's certainly worthwhile. First thing in a divorce should always be looking at, can we set up a child maintenance trust if that is possible. The only other one there is for paragraph 2C that we've got here. Paragraph 2C does not apply unless the beneficiary trust concerned will, under the terms of the trust, acquire the trust property when the trust ends. So again, if we do that, and the good thing about that is generally it means if we wind up the trust, then it has to, the only people who can receive that are obviously the beneficiaries if they are alive or their estate. Of course, if you set up a jurisdiction in South Australia, then the rule against perpetuities doesn't apply. So that's a bit of a benefit there. So let's just have a look on three areas. I put this slide in here. So I'm going to take you through. I just want to give you a bit of a heads up. Are you there, Tone?
Yep, absolutely.
So do you just want to go through Tier 1, Tier 2, Tier 3? This has been operating for a year now, but we probably haven't elaborated on it to any great extent. So if you want to cover Tier 1, Tier 2, and then I'll cover Tier 3, how's that?
Okay, all right. So Tier 1 basically is where where the client actually prepares its own will, in effectively its own EPOA through the data capture sheet with the advisor, and there's no legal sign off on that, right? So it's prepared by the advisor. There's no PI coverage from AM at all, except for documents. The client's responsible, and the client's to seek its own advice, basically. So what the advisor should do in that instance is is advise his client at the end of the day whether he wants legal sign-off on it. If not, make sure that the advisor actually writes out to its client confirming those instructions,
which is what
it on file.
Effectively what we'll do, you'll see when you get into that testamentary trust that we've got a couple of letters there that Tony was talking to. We've got letter instructions how to execute the will, but also that the preparation of the will, the EPOA, effectively is done from a data capture prepared by the client. And as a consequence of that, if you've seen when we did our 4-hour session, Tony went through that extensively. So that sort of covers there. Now, Tier 2 is where there's Abbott Mourly mentoring you through the process.
Yep, and that's basically what you get is the cost is a flat rate, $4.95 for individuals, and if it's for couples, it's $8.95. And what that includes also is preparation by the advisor, and then obviously you get PI coverage from us all round. And there for simple wills and TTs and EPOAs, the client actually gets 2 Zooms with us. So that's all part and parcel of the 5-step roadmap. It also gets the opportunity, we also get the opportunity to review documents also. And there's legal sign off, of course, by AM. And also to that, as part of that bundle, you also get the customization on it too. So if the client, in other words, needs any amendments done to the will or any specifics or customizations, we can do that. So that's the Tier 2 bundle.
So that to me is, look, it's awesome value because usually you're going to come in with testamentary trusts, and you're obviously going to have EPOAs, probably an SMSF will, particularly if you're looking at that super. Remember, we want to set up the SMSF Death Benefits Trust. That's pretty good for a sign off. Honestly, that's great value, because you're going to be charging, if it's a couple, $3,500 to $4,000 for all those documents. So, $895 for that. Now, the Tier 3 is different, and we've been working with a couple of accounting firms. So Tier 3 applies for a couple of accounting firms we've been working through. Is they just don't have the time. They know the clients are seeking it. They don't have the time to do it. So what they do is they hand it over to us. So either a client will come through and go to the will, and then you'll just put them in touch with Tony, who will take you through the process. We have a Zoom meeting. We give them the data capture. So it's all the same sort of thing. But then essentially we set up a moat for them, so to cover a whole range of areas there for them. And then there's 3 Zooms. It's quite extensive. The first one, then the second, and then the third one is the sign-off. Now, we just charge our standard fees for that. But because you're heavily involved, because we'll need to liaise with you to find out what their assets are, where their assets are, etc. Then when we bill them, we then pay you a 30% administration fee. Have you got any? Because that's been working well, hasn't it, for you? Because we've done that for quite a few accounting firms, haven't we?
Yeah, absolutely. That's the Tier 3. I mean, always works, But if you want to go down to the 2, it's really up to the client or the advisor, basically.
Yeah, essentially. So most of the Tier 1, we know where it's covered. Tier 2, I saw with Gordon Black. That's available for people who are on strategist membership, also licensees, and also even if you've got a PAYG. But for those of you who haven't got the time, or you don't feel super confident at this stage, let us do the first few and work through with a few. So look at it as on-the-job training there. And really, at the end of the day, we're doing all the work. But, if it's a $4,000 job, effectively you're going to end up with $1,200. So it's a pretty good fee there. And we've got a scale of fees there as to what you should expect from each one. But so if you're interested in that, just let us know. Sorry, go on.
No, that's all right, mate. Just with the tier 3 aspect of it. The advisors that I deal with basically are on that Tier 3 because one, they may be, a 1 or 2 partner firm, which they really haven't got the time at the end of the day to.
Yeah, we find that's usually the time.
And that's time. And rather than spending time data capturing, the accountant or the planner could actually be doing other billable time with his clients, capturing other value in the business. You know what I mean? So the 30% administration fee is much more suited to some of the advisors at the end of the day,
Yeah, definitely. So look, it's up to you. Feel free to contact us any point in time. Phil Scandiza, good to see you, Phil. You're always here. So you must be learning so much. But if you've got an insurance policy, then make the beneficiary certainly not the estate, because otherwise you're going to get caught up in, remember, 2A, 2AA and family provisions. So it's best to go down to nominate the beneficiaries who are to receive it, and then the trust can be created from that one as well, which is important. So we've got a financial planner couldn't accept those fees due to FASEA. It's not a referral fee, Julie. It's up to you. So you can either look at it one or two ways. It's either it's up to you as to what you want to do in that one. But let's take that offside. And Julie, thank you for getting up so early in Western Australia. We can work out some other arrangement, perhaps, that there's a credit over to your LightYear Docs subscription of that administration fee. But anyway, let's take that online. Again, this is a true administration fee for your preparation of a lot of the material. So there is actually work done, believe it or not. It's not a referral fee. Okay, let's go down and have a look at, there's your roadmap. You've all seen that. Let's have a quick look at the Testamentary Trust. So I've got John Smith's a 60-year-old doctor with his own practice and also a locum at 2 local hospitals. He operates his business via discretionary trust. So this again was in our 4-hour session we did a couple of weeks ago, and I'll show you where that's a little bit later on. John and Sally are married, have their investment properties, have 3 investment properties worth a total 2.2 mil with $300,000 in debt, an SMSF with 1.4 million in his lump sum account, and 1 million in Sally's account with John and Sally as trustees. So there's a lot of work around that SMSF. I'm not going to spend time on that one at this present point in time, but we'll have a look at a couple of issues around that. Sorry. They live at a property in Manly in New South Wales with their disabled daughter. The house is owned jointly with no debt. Actually, it's not owned jointly. Sorry, the property is in his own name. So I just want to show you what a life tenancy is. So let me just bounce that out of there because I want to give you these slides as well, which is pretty important. So let me just go there. Is owned with no debt. The property is in his own name. So I just want to show you what a life tenancy looks like, if that makes sense. So let's go back and have a look. So he's got his 3 properties. The next slide is the children. John and Sally have 3 children. Max, age 35, successful stockbroker. Chip off the old bloke, lives in Sydney with his wife Samantha and 2 children, Kathy and Janine. So he's obviously got his own children. Sarah, who's a 32-year-old doctor working country New South Wales and estranged from the father. So that, as soon as you see that, you can see the lights flashing. You're thinking, uh-oh, family provisions, family provisions. Jodie, who's 21, is the disabled daughter who's still living at home. So we've got a really good little mix there. As soon as you do that, I would say, obviously, you're not going to do it yourself. Liam, sorry if I missed this. What is the AM fee for the option 3? Sorry, the Abbott Mourly fee is we're engaged by the clients directly. So we just charge our standard fees for the preparation of the documents. And quite often, if they're working with you, it's for example, I think a Testamentary Trust is $1,800, but if there's a couple, I think it's about $3,000, and that includes EPOAs, and then there's obviously upgrades of deeds, etc. So then what'll happen is you'll then get 30% of that. But if you want, Liam, just contact Tony at Anamourlis, Abbott-Mourly.com.au, and I've got a fee split there as to exactly how it relates of what we charge and then what you would expect out of that.
Can I just jump in there for 2 secs?
Yeah.
Right. Just with that, with Liam and Julie, look, you'll be surprised once you go through the journey with me, with a client. Out of those 2 or 3 Zooms, it just takes up a lot of time, and you'll see that for yourself, basically, in terms of what needs to be done. So easily you could rack up fees at the end of the day. If you were doing it on an hourly rate at the end of the day, I mean, it just wouldn't be.
It's not feasible. We do everything. Yeah, we do everything fixed fee, which is important. But again, it's going to be for, generally we find it's for the hard ones that you'll do. John's completed his will, his family solicitor in 2010, giving all of his estate to his former wife and a B2B end directing to the trustees. So you don't want to basically do that. Okay, so what does John want? So looking after his family is important, 9 out of 10. So Sally's to remain in the house for life and then go to the children, Max and Sarah, to get then go to the children. So that would include, obviously, Jodie as well. Max and Sarah to get $200,000 from super. So that can be paid directly to Max and Sarah because they're both children. So therefore, their dependents are the SIS Act. We won't have time today, but with our SMSF will, I think I've got a training session coming up very shortly on that the next month or so. When that's paid out, then you can create an SMSF Death Benefits Trust for that. I mean, obviously, if it's only $100,000, it's generally not worth it. Sarah's also to get the investment property, Batinia up here in Queensland, and it's optional to go into the trust. The remainder of the estate is to go to Sally. So she's to get 50%, Max 25%, and Jodie 25% as well. Super to go to Sally's an income stream and then go to Jodie for her life. Because she's a disabled child, then the the commutation at age 25 rule doesn't apply. So what we'd be doing is obviously paying an income stream to Sally with a reversion going to Jodie. and they can come from the superannuation fund. So let's go, let's just jump out of there. And what I'm going to do is I'll have a look just to give you an idea at what the end product is. So rather than glossing over that, I will come down and have a look. I think I've got, okay. Okay, so let me go into my, I don't think I've got one. Let me go into my document storage. I did one today for you. Let's go through it pretty quickly. It's not that difficult. Once you get it, again, I'll just take you through the process here. So this is the one that I've done this morning. So will with Testamentary Trust, enduring power of attorney. I'm just going to relaunch that. The good thing about our system is that, look, if circumstances change, you can go back in and do a brand new will and testamentary trust with the client. For example, if something happens to Jodie and she passes away as a disabled child, then you go in and just fix everything up rather than just letting it stay. And all you have to do is just relaunch. So I'll go through this process and then I'll show you the document. So I've got Smith, Will and TT, and then I've used the Abbott Mourly logo. Now, the important part of it is we want to put all our common parties in. Just makes things a lot easier when we go through. I've got John Smith, wife Sally Smith. Remember the stockbroker Max that I put in there is from Fairlight. Sarah, the estranged girl who's living in the country in Dubbo. Joni, who's, I think it's Joni. Yeah, Joni, or it should be Jodie, I think. Actually, I made a mistake. So, sorry, it's Jodie. And she's living with, obviously, Max. And we've got Jeff Smith, who's the Max's brother. Oh, sorry, Max's John's brother. So that's the family we've put in there. Now, the documents we've got here is, I'm going to use New South Wales enduring power of attorney. I'm going to do a will with Testamentary Trust. And remember Tony talking about it earlier that if you're preparing this from a data capture, so it's not option 2 or option 3, it's that option 1, so that you're not requiring sign off. So if it's that option, if it's that option 1, then effectively you'll want to make sure you tick this yes box. And then what that does is prepares a letter saying that you've got an enduring power of will that's prepared based on Abbott Mourly precedents from a data capture that's prepared by the client and is in no way to be treated as the provision of legal advice. We go down the enduring power of attorney. Obviously, the principal is John Smith. We've got then Sally Smith, who's the attorney, but we've got joint attorneys there. So I've made Max and also Sally. The replacement attorney, if Sally and Max are bankrupt, don't want to do it, retired, dead, deceased, disabled, then we've got Jeff in there as a separate. We can keep on going down to a second replacement attorney, but I've gone no in that. So again, when you tick boxes in our system, and they need to be ticked because otherwise you'll stuff up the document. So the power of attorney, a couple of things here is, one is by ticking this box, you're giving authority for the enduring power of attorney to act as the trustee or replacement director of the corporate trustee of an SMSF. So that comes up through the system. So that's built into the EPOA. The second one, which is typical, do anything on behalf of the principal can lawfully be done by an attorney, both personal, financial. And then thirdly, this is where your client has a company or is involved in a company. For example, it might be a bucket company. It may well be a company running a business where they're the sole director. Alternatively, even if they've got an investment company. So, for example, if Tony and I are in there, I want to have a successor director in the case of something happened to me around Abbott Mourly, which is a brand name of TGA Legal Proprietary Limited. Just someone to represent my directorship, although I do trust Tony implicitly anyway. I'd probably resurrect the old, my dad, or get some other poobah to step in just to make sure. Anyway, we put that in and I'm going to show you what that looks like, because if I take that out, you'll see on the left-hand side, see where it says power of attorney, just watch what happens when I tick that, bang. So up comes the company. So that prepares specific documentation for successor directors through incapacity, death, or their own choosing. So that's one itself, which, to have that is absolutely crucial. So when's it going to commence? So upon signing the document, does the principal want to revoke previous appointment of attorneys? Yes. In New South Wales, Section 19 requires a solicitor sign off. So you can actually have Tony sign off. If it's just an EPOA, then it's $150 from Tony, or you can take it to your local solicitor. But again, we just wrap all of that up into your fee, so as part of the total fee sign off. Remember, under point 2. But if you're doing it under tier 1, then effectively you'll need Tony to sign off there as well. You've got a choice, is it jointly or severally? And then you've got some separate powers of attorney. Authorise my attorney to give reasonable gifts, which is okay. Authorise my attorney to confer benefits on the attorney to meet reasonable level of medical expenses. So I might just choose those two. And then I can put in additional ones. So I've got here, for serious health issues, please refer to my advanced care directive. So that's my EPOA. Here I've got my company, which is Bogan. Both John and Sally are sitting there. Just remember, Sally's the second spouse. So if I'm doing that, I might choose, okay, I've got Sally. I might actually take Sally out as the enduring power of attorney. And you see, you just go up to that little box and I delete that repetition. So now Sally's out of the equation. So if I go to my attorney, I'm going to go in, I've deleted those. I'm going to put Max Smith in there. So she's now there, but it also means now in the event of my John's death, Max comes in and would take the directorship on Bogan Proprietary Limited. Now let's go through the estate. Is there a life interest? Yes. So we've got a life interest in this. Remember, this is obviously going to be over the main property. Would you like to make another will for the spouse? I'm going to say no in this one because I'm just going to have the time. So if I do, though, you can see down here, we set up a separate will for the spouse. And then when you go through the spouse, you can go through a life interest, which would be no. You can also do an enduring power of attorney and also, again, that client's data capture to sign off. So again, by going through this process, you can end up with not 4, but 6 documents, an EPOA, a set of resolutions for successor directors, and will with testamentary trust. And for a couple, that's 6 documents. So look, it's a great system. But what I'm going to do here is I'm going to say no. But again, we'll go through. So the testator is John Smith. Put your details down there as the accounting because you want to be the administrator of the estate or the advisor to the executor, which is important. With the executor, I've made Sally and also Max here, which is not too bad. Successor executor, we've got Jeff in case those two aren't around or they die or whatever. Second successor, I've chosen no because we've got 3 people to actually go through. Now, the binding vote for the executor, if it's Sally and Max, who's going to have the binding vote? So let's just change that to Max. And all of these things, in fact, the best way to do this is sit with a client. You can either have this open or if you're doing a Zoom, obviously you've got Sally and Max, who do you want to have the casting vote? So let's go to the principal beneficiary. I've gone Sally Smith, a spouse, 50% of my legal estate. Now, we've got to work out that if she's not alive, where does it go to? So what we'll do is we'll pay it to the secondary beneficiary. So I've either got a choice there that 50%, I could pay it to the other principal beneficiary. So if she's not around, it goes to Jody, or it can go to the secondary, which will go down. So in this instance, I'm just going to pay it to the secondary beneficiary. Is it to go into a testamentary trust? No. So that's obviously she doesn't need a testamentary trust. She's quite older in the piece. Jody is to get 50%. And again, if she's not around, it's going to be paid to the secondary beneficiary. But I've got a choice there is this to go into testamentary trust? We go absolutely. Now, the question here is this beneficiary's share of the estate to be automatically transferred? So the executor will automatically transfer to a testamentary trust. There's no ifs or buts. It must go in there. So I've ticked yes there. Is the spouse to be included along with the main beneficiary? Well, we don't know her whether she's got a spouse yet, but I'd go no, because I've seen too many instances where disabled children end up with people who might get involved. So again, take the spouse out of there. You can always add them as a separate beneficiary later on. Do you want the secondary beneficiary bloodline or lineage? Yeah, just in case if something happens to Jodie, we've set this trust up, and if she passes away, then the secondary beneficiary could be bloodline or lineage. Are there any related entities such as trust or company? Have we got a bucket company? No, but we can always put that in later on. Is the main beneficiary the appointor? No, because she's disabled. So here we could put Max Smith is to be the appointor and trustee of the trust for Jodie Smith. And I think that's basically it. So that's the testamentary trust, the terms and conditions. So I'm going to come back and have a look at that. So the secondary beneficiary is Max Smith. So for example, if Sally's not alive, it goes to the secondary beneficiary. Alternatively, as I said, it could have gone there, or it could have just been played to bloodline. Or you'll see here when we go to Max, Max has got children, remember? He's got Janine and Kathy. So 75% of the residual estate goes to Max. And then if he's not alive, it goes to his bloodline children. So again, that's Janine and Kathy, and is to be created. Importantly, all these testamentary trusts and all that are to be created by the executor. So you can't create a testamentary trust in a will, because you need property to settle a trust. A trust is not a trust until there's property settled into it. So they're all created by the executor on death out of the will, and that matches section 102 AG2. So when we do that, effectively, this particular trust, again, would be a testamentary trust, but it's going to be created by the executor, and it'll be for the benefit of Janine and Kathy. And then we've got to go through all the issues. Now, this is for Max. So do we want to go to testamentary trust? Yes. Is the beneficiary share of the estate to be automatically transferred? No. Because look, Max is a smart person. We want to give him the opportunity to do it in testamentary trust. But if he wants to do it, it needs to be his consent. Is the spouse to be included along with the main beneficiary? We've got yes. Is the secondary beneficiaries be bloodline or lineage? Absolutely, because we want those secondary beneficiaries to be Kathy and Janine. Are there any related entities? Yes. So we could put in there bucket company. I'll just go, I'll just go yes. Is the main beneficiary the appointor? Yes. And so, it's a good testamentary trust there for Max. Now, you note how I've got 75% of my residual estate there. What I need to do, though, is I'm missing 25% in case both Sally and Jodie, if Sally's not alive, it needs to go in. So I need to go down and I need to add another. So what I'm going to do here is I'm going to add Sarah. She's the daughter. And then she's to get 25% of the residual estate. So that's all dependent on everything else. Now, if she's not around, then it's just to be played to the bloodline beneficiaries, which can include, obviously, Jeff can be part of that process. So we've got that one there. I mean, obviously, if they're not around. Tertiary beneficiary, I've got there Sarah. Again, she's to get all my remaining estate. I'll pay to bloodline beneficiary. Do you want to go testamentary trust? We'll go no for that one. I've got, let's just go down a couple and then I'll come in and have a look. So I'm sorry, I'm going to be about another 15 minutes. But again, this is recorded, will be up if you have to jump out. So specific gifts, well, we have got one. Remember, the investment property in Batinia has to go to Sarah. So she's being paid out. So who should shoulder the expenses? So that would be the beneficiary there. Details of the specific gift. It's going to go to Sarah, who's my child. And that is the property. It'd be great to have the portfolio number. The property at 100 Batinia. Can't even spell it. Batinia Road, don't know why I chose such a hard one to spell. Virginia, Queensland. So that's to go to Jody. Is it to go to a testamentary trust? Well, I could make it voluntarily, but I'm just going to go no for that one. So I tick no. Now, digital assets. Yes, if I've got any. Would you like to appoint a separate digital executor? No. So that's okay. So our executors, obviously, Max is going to be smarter about it. So I could put all my digital assets there. So I'm going to put Bitcoin. Where to access BTX exchange. Username, see my vault. And that's also see my vault. And additional access information, so I won't worry about that. So that's a digital if you want. Child guardianship is obviously not an issue here because, you know, the children, actually there is an issue, guardianship, so I'd go yes. Select the children is actually going to be, so again, this is only if John and Sally's not there. So you can still do this, but you're picking up. So Jody, name of the child, and then we're going to be Max Smith is going to look after Jody. And then succeeding a guardian, we might make it Jeff Smith and Sally Smith. Second one, we might make then Sarah as the second succeeding. So again, that's just for Jody, but it only work, for example, if John dies and Sally's still alive, then obviously it's going to be Sally. So this is the event they're both not there. We go down to pet guardianship. Well, no, we'll go no there. Life tenant of the property. So it's 5 Smith Street, Sydney. Life tenants will be provided with reasonable expenses. So if it's 5 Smith Street, it goes to Jody and also Sally. Funeral wishes to be buried at Rookwood Cemetery. So I've gone down that. I'll just render it. And then we'll have a look at the documentation. So we'll go through that. It's not huge, but we'll have a look at how the testamentary trusts work. I'll just, while that's coming up, I'll just answer a couple of questions we've got there. As you can see, it's not super sophisticated. We've done all the hard work for you. So Phil Scandizo. So Tony, do you want to explain? So the question there is, if it's just produced on our system through a data capture, so just a basic will, what the sign-off means from that perspective.
It's pretty, look, at the end of the day, notwithstanding that the documents are produced by LY and is, you know, via the interviewing process, all AM will do at the end of the day, if it goes down that path, is produce, as part of the tier 1, is just a letter of instruction as to how the will maker is to execute their will and EPOA, basically. That's what it is.
Yeah, so when it comes out, it's just a typical sign-off for under all LightYear Docs documents that there's been signed off by Abbott Mourly, and then you've got the preparation of the documents by way of a data capture or an interview process.
And further to that, if they require legal sign-off, when we talk about legal sign-off in its broad sense, I guess, at the end of the day, they have to go through a process, right, like tier 2. You know, where you engage basically and take the journey through with the client and the advisor of, you know, reviewing the actual wills, talking to the client, seeing if the client wants any amendments done to those documents, and then it goes through a review process again. Then we come back for a second Zoom where we take it through finalisation and execution. That's where we talk about legal sign-off, basically.
So that's tier 2. So you covered from a general perspective, and that's why you want to keep things simple. But once you start to get potentially contested wills, and remember what I'm doing now is going to be potentially subject to family provisions claim. So it's nice to have, but again, you know, you might be better with a family protection trust, etc.
Sorry, mate, but I don't want to take up too much of your time, but I just want to explain something here, right? We had a client 2 weeks ago, right? An advisor. He filled out all the data capture sheet and it was the full complete, mate, basically, right? So he fills it all out. He's the client states basically, "Yep, I'm happy with all this. You know, how do we get it signed off? Basically, we have to go through a lawyer, or what do we need to do?" So the actual letter of instruction went out to him. Once the documents were prepared, it just spits out basically a letter. How to sign off on a will, how to sign off on the EPOA. But then the advisor rang me actually and said, "Look, we've just prepared a the moat. Would you be able to review it?" I said, "Yeah, sure, I can review it for you, but you know, then you fall into this tier two situation." What had happened was the will maker has got 5 kids,
Yeah.
right? Have a listen to this, mate. Have a listen to this. And he was happy with that, right? The will maker had 5 children, okay? 3 adults and 2 minors, okay? What he was doing was he wanted to give 100% of the estate to his second wife, right? Because he had been previously married, because he had been previously married 2 times previously to that, right? And then what he wanted to do, if his second wife wasn't alive, then the only secondary beneficiary that he wanted to give all of his estate, excluding his other adult children, was to give it to a 5-year-old alone and exclude all others. I
So
said, "Well,
that's where you
that's
need
an
to protect
alarm
it.
bell." Alarm
Yeah.
bell started ringing on me. I said, "Well, this is the situation, Mr. Advisor. This is what it's going to fall into in some point in time. You're going to have family provision claims here challenged. So it's really up to you at the end of the day whether you want legal advice or legal sign-off, if you want to call it." So probably within 48 hours, I got onto the client. The client got onto a Zoom with me, and I started explaining, started giving him advice basically about the whole situation or his scenario. And he came back with an email, probably a couple of days later, and he said to me, "Tony, listen up, mate. What I want to do is give 50% of my estate to my second wife, and 50% to be shared equally between amongst the kids, basically. So
Yeah.
we
I
won't have
know.
this problem." That's the difference when we talk about legal sign-off, mate,
Yeah, so that's where we generally do a moat. We do have a number of planners who are just doing basic wills, just mum and dad will. So when you do that, that's pretty simple. That's just your basic. Once you start getting a testamentary trust, multiple children, any of those ones, which you can see here, this is the letter of sign-off, Phil, is the attached will and EPO is based on data capture given to you by a blind accounting firm. It uses legal precedents from Abbott Mourly, which is a sign-off. You've got your EPOA, you've got your will, and basically there's a disclaimer there. It's important that you read the following as the legal nature extends beyond the data capture and the administrative process completed by a blind accounting firm who are not solicitors. So we go through the documents that are attached, the will. So this is all part of the kit that you give to the client. But importantly here, as we said, if you have a look at Tony's one, wills can be challenged to the Supreme Court by any eligible person, including children, grandchildren, ex-spouses or others. So if any of the following occurred or are likely to occur, please contact blind accounting firm. And so that's like, are you getting married in the near future? Are you separated? Do you have an ex-spouse? Do you wish to exclude any close family members? Do any of your beneficiaries have, mental, physical, big spenders, bankruptcy issues? So once we start to look at that now takes me, you generally, if you've got any of this, you want to move anyway from your own perspective from tier 1 to tier 2. And if you think it's going to take a lot of time and you haven't got the time, then just go straight to tier 3, which is perfect. You get obviously the general advice letter, which talks about the process of executing. But if you're in tier 2 or tier 3, then obviously Tony will actually do that execution process with you via Zoom.
So
We've got our enduring power. Sorry, go on, Tony.
No, the most important thing at the end of the day, right, is with tier 1, you don't get the benefit of PI coverage. Simple.
Yeah,
right?
simple.
Tier 3, tier 2 and tier 3, you get the benefit of PI cover. Simple.
Well, effectively, it's because the documents are being prepared by Abbott Mourly.
Exactly.
So enduring power of attorney. So we remember we had a look at this a while ago. So you can do anything you can do. The superannuation fund trustee and also a successor director. So I know a lot of you probably haven't, most EPOAs I see don't have this. So it's worthwhile for your clients if they've got an SMSF, they must have this EPOA. So I'd strongly recommend that you get your clients upgrading with a EPOA. And you see that I've actually got something in our email for that. And that's where Tony comes in and signs off here. Sorry, Tony.
Yeah, that's right. Because I'll tell you why with these EPOAs, I've seen EPOAs at the end of the day that, date back to 2003, 2001. And you've got an estate sitting there, which I'm presently dealing with one now, $12.5, $15 million estate. And it doesn't give any provision about successive directors or replacement directors at the end of the day. So what would happen if the will maker had passed away? What happens then?
I know. So that's why this is great, because this includes successor directors. So this is the first document we looked at was the EPOA. Now this is the second one, where the chairperson tabled a motion to appoint Max Smith to act as successor director when requested by the current director, where the current director loses mental capacity, becomes bankrupt, or dies. And then this is what the company has to do. But once that's in, then they're legally binding. So that's a great one. You can do that for as many as you want. We're put in here just for your own benefit anyway, is that when you've gone through and you prepare the documentation, this also does the data capture so that you can send this to the client. Just say, look, they might have sent one in. Just say, look, can you confirm that this is definitely the data? This is all what you want. Again, it goes back to that letter. So we get down. I'll be another 5 minutes, and so we're getting down to the Testamentary Trust. So this will is made on, obviously you're going to put the date in, or you relaunch and put the date in, by John Smith as correct and true record of my wishes, bequests and testaments for my legal estate upon my demise. However, it does not seek to influence or direct any trust or super fund where I was a trustee or beneficiary at the time, so on and so forth. So, because that's not valid at law. So I hereby revoke all formal wills and testamentary dispositions, which are important. I appoint the executors. Now, remember, it was Sally and Max. Now, in the event of tied vote, it's Max. And then if Sally and Max predecease me or are unable to willing or continue act as executor, then Jeff Smith. So that's my succession planning, which is basically sitting in there for my executors. And remember, I had a similar sort of one for my EPOA. I had Max as the primary one, and then I think it was Sally as the secondary. Now, the ongoing trustees. So my executor should be the initial trustee or trustees of every trust established by my will, including life, tenant trust, testamentary trust, the super proceeds trust, unless my will provides otherwise, which is what we're looking at. Now, this is the important one. So we're going through a process. So we've appointed the executor. We've said, okay, well, the executors are essentially trustees of any trust. So you've covered that thing. Now, this is where you guys come in, the provision of advice. It is my strong wish that my executor obtains and considers advice from my advisor, Blunt's Accountants of DY, in making business management investment decisions when administering my estate. So that's crucial, because you're not the executor, but you're really closely in tune with the executor. You'll be setting up all these testamentary trusts, a super SMSF death benefits trust. All of these ones will be on your advice. And again, can be quite lucrative as well. So now the initial administration. So I just want to cover a couple of things here. So my executor shall, subject to its powers, sell, call in and convert into money any part of my estate, and subject to the subseding clause, pay any debts, taxes, contributions, funeral, or other expenses of the testamentary. So just on that one, Tony and I think, what date did we set? Was it the 11th or the 13th of November? We're doing a 2.5 hour session on estate planning 101, and more importantly, administering estates. Yeah. So going through probate. So make sure you're on that session with us, because then that will cover what the executor's doing here. So there's just one paragraph, but for example, if you've got a protector, and then there's a loan to John Smith, then part of that loan will be that the executor of the estate must repay that loan into that family protection trust. And again, so that whips some money out of the estate from family provisions and purposes. And then it says next one, so you pay all your expenses, taxes, whatever you're left over. So my executor shall then deal with the balance of my estate remaining after the payment discharge of testamentary expenses. We go down to the beneficiaries. We've got spouse, Sally Smith, disabled, daughter, Jody, and so on. Now, any specific requests may require the trustee to establish a testamentary trust. So we've got here, in the event that Sarah Smith survives me by more than 30 days, they take a full and complete interest in the property of Bettinia. So that's the first thing. So there's no residual estate, but all expenses are to be borne by the beneficiary. Remember we did that? Mm-hmm. Now the life interest. So because remember the property was John's, so it now divests itself to the executor. Now, if Sally and Jody Smith survives me by 30 days, my executor shall hold the life tenant property at 5 Smith on trust for Sally and Jody as the life tenant for their life only. Such trust known as the life tenant trust shall be established under the following terms and conditions. Shall be for a period of 80 years maximum, as long as the life tenant remains alive. The trustee is to be the executor or such other successor executor. Reasonable expenses for upkeep and maintenance. Property cannot be sublet or leased to another party without the consent of the executor. It's got to be kept in good condition. And then the trustee, with the consent of the life tenant, may dispose of the life tenant property. However, any residual proceeds may be kept in the life tenant trust with net income to be paid to Sally and Jody Smith. So it's a pretty good life tenancy trust that's built there. Again, there's two things there that we need to look at, is that this would be a separate trust that would then be created by the executor on the death of John Smith. So rather than putting all that life tenancy trust embedded into the document, which would be irrelevant because there's no trust until we get settlement proceeds, we do that on the death of the member, and it's done by the executor of the estate, who is being advised by you as the provisional advisor. So you can see that that session we're doing with Tony is absolutely crucial, that 101 on how to administer estates. Anyway, if we have a look. If my spouse, Sally, and my disabled Jody Smith survive me by 30 days, my executor shall hold any remaining estate, that's after the investment property, expenses, etc., including any super benefits paid to the estate. Now, obviously, we wouldn't do that. We'd do it in a separate way. For the benefit of my spouse, 50% for Sally and 50% for Jody. Remember, we did that in the system. So the benefit for Jody Smith is to be automatically transferred to a testamentary trust on the following terms and conditions. So it's for the benefit of Jody Smith as the primary beneficiary, which makes sense. The beneficiaries will extend to primary beneficiaries' bloodline or lineage children, relatives, or persons directly descended who share their DNA. So they could actually go to Jeff Smith. The executor is the initial appointer. The executor, unless otherwise decided by the testator, is to be the trustee of the trust or such other person or persons as executive directors, including any company. Max Smith is to be appointed and trustee of the trust for the Jody Smith. I'd probably, if it was me, I'd probably put in another term there that the trust needs to meet the conditions of a special disability trust under the Social Security Act. So I would put that in there as well. So if I wanted to, I just have to go back in and quite easily change my system. Now, Sally Smith's not alive. So remember, she's going to get 50% paid to her directly. Sally Smith's not alive. Her share is to be paid to my secondary beneficiaries. If Jody Smith's not alive, then it goes to secondary beneficiaries. Then if we go down here, secondary beneficiaries is Max and Sarah. So thank you very much for that, John. So you can see, I did that on purpose, John, of course. I meant to put 25, but I put 2 just to see if you guys were actually paying attention. But anyway, you know how easy I can go back and change it. Anyway, so Max Smith, remember this was the optional trust. Max Smith may transfer any part or all their entitlement to the residual trust estate under the following conditions, only upon Max Smith's consent. So that is voluntarily, it's not mandatory. For the benefit of Max Smith as the primary beneficiary and the spouse. Now, we could have taken the spouse out. The beneficiaries will extend the primary beneficiary's bloodline or lineage children. So that's obviously going to go to Janine and Kathy. And also any related entities where the primary beneficiary has an interest or controls the entity. Max Smith is the appointer and able to choose any successor appointers. And Max Smith is the guardian, Max Smith or their guardian is the trustee or director corporate trustee. So that's a set of T's and C's for a testamentary trust with an optional testamentary trust. Now, if Max Smith's not alive, it's to pass to their bloodline children may be held on trust, subject to executive's discretion and on the advice of the advisor to the estate. So you can see I'm putting you in a lot there. If Sarah's not a Smith alive, it's to be paid to any bloodline beneficiaries. So that, I mean, really, it'll end up probably being Jeff Smith as well. If in the event there are no beneficiaries immediately identifiable, may distribute the remainder of the estate to anyone who shares the same DNA. But if secondary beneficiaries are not alive, then Sarah pops in there. And again, there's no testamentary trust there. But again, if she's not alive, it goes to bloodline beneficiaries. A child guardianship, in the event of the death, I nominate the following person to act as guardian of my children. Now, remember, this is assuming Sally's not alive. So it's only Jodie Smith in this instance because the other ones are adults. So first guardian's Max, second is Jeff, and third is Sarah. And then is my wish and direction of the guardian ensure whether through any financial other income provided my children through this last one, tell us one, where they trust that my children are to lead a comfortable life, have the best schooling where finance appropriate and live in a manner they live prior to my demise. Funeral other wishes, buried at Rookwood Cemetery there. And then I think we've got digital up a little bit further. And then we go down to specific powers. We've also got a whole lot of specific powers around the different sorts of testamentary trusts. Includes prospective beneficiaries, so that could be, for example, future children. Digital assets sitting in there as well. Entitlement to charge payments. Testamentary trust powers. So we've got additional powers there that you'd be taking into account. You can do parallel testamentary trusts, amalgamated, restricted, split. We'll look at all that on the day. But again, you can see there, executed by the testator. We've got a separate schedule there for your digital assets, Bitcoin, who looks after, etc., and then signed by the executor. So that's our will with testamentary trust. As you can see, to actually draft that, which would be the provision of legal advice, would take a long time. But what we've done is we've made it as simple as possible, because what I'd have to do now is I just go in there, back in the document storage. I think, oh gosh, I've made a couple of mistakes there. I go down to Abbott Trust, Abbott Test, so it's just piling up. I go down to the last one, which is the Smith, Will and TT. I'm relaunching there. So remember, I can just go in. I can say, okay, well, unfortunately, Sarah's just passed away. So what I do is I go in and let's reinvigorate the whole thing. So I've still got Sarah Smith. So unfortunately, Sarah Smith's passed away, so I can delete that repetition, as you can see. So when I go through, I've got my enduring power of attorney, John Max Smith, replacement attorney there. And now I had obviously Sarah there. So what I'll do is I'll put Jeff Smith in that one there. So then we go down the power of attorney. That hasn't changed. Company hasn't changed. General. We go down to the testator, executor, successor executors. So I'll put in there Jeff Smith. Second successor, we don't need one. Binding vote is going to be the same. Principal beneficiary, Sally. Jeff's going to be the same. Secondary beneficiary, 75% Jodie. There I've got to change that to 25%. Tertiary beneficiary, is now Jodie Smith, but she would have been covered, so I'm going to make that Jeff Smith. Specific gifts, I'm going to go no, remember, because that was going to go to Sarah. Digital assets, that's all the same. Child guardianship, so I've got Jeff Smith, Max Smith, and then obviously there's none here, so I just got to take that out and leave that blank. Pet guardianship, life tenancy, funeral wishes, and that's it. So that's how easy it is. If Sarah dies or is now completely estranged, doesn't want to have anything to do with the family, then that's how easy it is you might have put that will in 2 years ago and now to reinvigorate it. So again, it's a great system, but all you have to do is you're just ticking and flicking. But anyway, look, that's the end of the session. What I want to do is we've got, again, just going up here, those three processes. There's a couple of questions that I've got here. Am I correct in saying that any real estate transfer to a TT does not involve any stamp duty? Is that correct, isn't it, Tony?
Yeah, well, as it stands now, that's
Yep.
right. Exactly. May change in, I don't know, in 5 years or whatever. So,
Okay. So
anyway.
a really good question here from Phil. Well done. So Grant, can you explain how the assets in a protected trust would be dealt with on the death of a testator? Absolutely. So, for example, remember the protected trust, if there's actually put shares in, then it's going to be, this sits quite separate from the estate. It's not a testamentary trust. Obviously, any children partaking of the family protection trust, which has been set up prior to death, would be paying tax at marginal tax rates. However, if you remember, the protector, it's a gift and then a loan back to John. In that instance, if John passes away, then that loan would be recalled by the family protection trust trustee, which in this instance you generally would assume would be Max Smith from a succession perspective. So that would then, the first thing would obviously have to be paid, would be that loan, any tax, so on and so forth. The next one would be the specific gift to Sarah, and then we go down the principal, secondary, so on, beneficiaries. As you can see, what I've done is it's not that difficult to do testamentary and life trusts. I think we ended up with about 3 or 4 there. Then we've got there, can you make changes after 2 years? Yes. For people who are on our subscription or our licenses, the documents are open indefinitely. So hopefully that answers your question, so that if there's any changes, you can always come back in and make them, which really puts you in a good position. Anyway, I think that's the final slide I wanted to show you is part of this process. What we're doing is obviously the Succession Asset Protection Estate Planning Advisors Association. We are going to have a working group up and running. So we've had a lot of interest from you, but that'll probably be after our estate planning session, Tony, and ours at 101, which will come up in November. We'll do this probably in the 3rd week in November. We'll go and set accreditation standards for nation membership, CPD. So it looked exciting, and the good thing about that is it will give us an accreditation, so we can put up the wall to say that we are proper advisors in this area. Anyway, thank you. Sorry, went on a little bit longer than normal, but I had to. I was in a toss-up this morning. I could have easily just given you the. A broad brush around the law, particularly around 102 AG. But given the fact is, I mean, you guys, honestly, the 70 or so people on here, you now know you're right on track of the latest in the testamentary trust, those anti-avoidance rules, the mixing. So you're in a really good position. Let's now start to leverage it. Work with Tony, have a chat with Tony. I'll send out his information a little bit later on, or you can get the details up from the Abbott Mourly website. And then we can work in tier 1, tier 2 or tier 3 if you want mentorship, or if you want us to do the full box and dice. And anyway, it's Grant Abbott, and also, are you there, Mick? Sorry I didn't get you on, but I know that, from an advising point of view, that you'd be well and truly up there. Are you there, Michael?
I am here, yes.
Yeah, so, I mean, obviously you're at the coalface dealing with clients and all that. I mean, how did you find that testamentary trust and all that? Would you feel comfortable going down, either doing an SMSF death benefits trust, a life insurance proceeds trust, or one of those testamentary trusts through an estate?
Yeah, I definitely would. I mean, I've played in that space for some time now, so I have a good, thorough understanding of it. But certainly, it is piqued my interest in relation to the Abbott Mourly offering as well, though. I think that's especially for the more complex estate planning matters, which I'm often coming across.
To be brutally honest, we've set the fees for our strategist members and licensees what I would call ridiculously low. Now, when you think of it, when you think that you'd be building a moat and you're getting sign off for a lot, but again, we're there to help and support you down that track. But also that tier 3, I know that a lot of you are too busy, but the last thing you want is your clients to run off somewhere else and get their estate and their enduring powers of attorney and SMSF wills somewhere else. So we are there for that full service suite. But again, you'll still get a fee there because we are going to have to lean on you for with administration. We're going to have to lean on you in terms of getting relevant financials, etc. So it's a true partnership. But anyway, thanks for all your time. It's pretty exciting, I think, that we're actually this in the system. As you can see, it doesn't take that long. It's not over sophisticated. As our good friend Travis would say, make sure you go and do it for yourself. And I think we could all sort of attest to that fact. So I think it's absolutely interesting. Anyway, thank you very much for that, and all of you turning up. It's Grant Abbott, Michael, and also Tony signing off. See you guys.
Thank you. Bye-bye.
Thank you.